Hi, I'm Denice Gierach of the 𝐬𝐩𝐞𝐚 Law Firm. This is another video in our series about selling your business. This video focuses on what can go wrong after the sale of the business. Once the sale is completed and the seller has had their confetti and a celebratory champagne, is there anything that can go wrong after the sale of the business? Unfortunately, the answer is yes. While no one wants to think about problems after the sale of the business, many times there are things that crop up, some of which should have been dealt with by the parties while they were still in the process of negotiating the agreement, and others that neither party could have thought would have been coming. One is the buyer and the seller get into a disagreement where they simply cannot work together. The seller does not even want to be in the same room as the buyer, and yet this was what was agreed to, that they both had to work together to cement those relationships. So how do they get around that when they have a real personality problem and it's a problem to integrate to the new team? So this can be a result of a difference in culture between the buyer and the seller's businesses. It can also be a problem with the integrity that's between those two businesses. The buyer's team may have a person in it that thought that the job the seller was doing was theirs, and that they would do things to undermine the relationship. The reality is that the buyer needs the seller, and the seller needs the buyer, especially if the seller left some ownership on the table. Both parties have to work this out, even if it requires a mediator to make it work, or they're both going to lose. So the sales agreement usually includes a list of included assets, as well as a list of excluded assets. The seller may have forgotten to include concepts, or exclude, I should say, the concepts that they're working on, and they're not intending to go with on the sale. So now the seller is thinking that they're going to be using these concepts to go into a new business. And so now there's a dispute between buyer and seller as to who should own those concepts, the trademarks or the different patents and what have you, because it wasn't specifically stated. So the exhibits that are to these agreements are very important, and both buyer and seller have to review these to see what's included and what's excluded. The sales agreement also may contain a number of warranties, usually a lot more than the seller wants to agree to. The seller does the best that they can in verifying the information that there are no issues with the warranties that are made, but something can turn up that shows that the warranty may not have been true as of the date of the contract when it was signed. It could be a misstatement in the financial statements that fail to list certain contingent liabilities that turn up. Who's responsible then? It's possible that another company disputes the rights to a trade name for the company, as the seller may have had the use of that name protected only in the state of the company that the company's located in. But now the buyer is or going into other states, so that wasn't really protected. So who's responsible then? Another is a lawsuit turns up against the company, the buyer's company, for something that happened before closing. There's usually language in the contract that provides that the seller is still liable for this. Did the seller maintain a tail policy to cover the possible liability from an insurance context, or just cancel the insurance on the date of closing? The seller decides to open a new business, which may be in another industry or has a different product, and then decides to use that customer list to promote it. Was this properly excluded from the restrictive covenants? Another is what is included and what is not included in the EBITDA for purposes of determining that bonus in the employment agreement. If this is not set in there properly, you will have another dispute between the seller and the buyer. After closing, the buyer discovers that there are tax issues that pop up. Usually the buyer requires a bulk sales stop order to be done as part of the contract to turn up any payroll tax and state liabilities prior to the sale. If this does not happen, it will not protect the buyer, and it also doesn't protect on federal liabilities. Sometimes part of the purchase price is based upon a formula, and both a buyer and seller may have a different interpretation of that formula. So this can happen when the parties think that the business may be worth more in the future than what it is now, maybe a royalty interest scenario or where there is seller financing. What if it turns out that someone is selling a similar product in violation of the seller's intellectual property rights? Who's responsible then? So sometimes, even with the best planning and being thorough in your approach to the contract and the sale before the deal ever closes, there still can turn up something that the parties will not agree about. This is just the reality of the merger and acquisition area. And the parties have to be aware about that fact. Each must do its proper due diligence to make sure that all relevant facts are disclosed prior to closing by the seller, and the buyer does their due diligence. Each party then can read their warranties thoroughly. The parties have a dispute resolution mechanism other than to go to court and spend a lot of time and money. Another thing is to be clear in the document and give an example for a formula that's a complex concept to help make sure that the parties are both going to understand it. Both parties must live up to their obligations under the agreement. Remember, the sale of the business should be a win-win situation for both buyer and seller. The seller has the proceeds of the sale to make a whole new life for the seller for a new business. The seller wants to do that, but the buyer has the opportunity to make this a growing business that he or she just bought. And so both parties need to step up and work together to make this a true win-win for both sides. Thanks so much for listening, and I'll look forward to seeing you at another video.